welcome back. Thank you for joining me. As you recall in the last video, we talked about who should be filing the removal of condition application, and we decided, or not we, but the service decided, it is all those individuals that entered into a marriage was less than 2 years, and you received a green card during that period. I also suggested that you pull up the I-751 so you're very much familiar with what they're asking of you. I went ahead and I pulled up the document myself. You can get this document at uscis.gov, uscis.gov, the home of all things immigration. You don't need to call the notario. You can simply get all your information from the source, uscis.gov. I pulled up the document. It is 11 pages long. That is fine. It also talks about the filing fee. Now I'm going to address two scenarios. Scenario number one, you are still happily married to the individual from whom you received your green card. Scenario number one, you are still in love. In that case, the service requires that you file a joint petition, meaning you're saying to the service, our marriage is still valid, we are still happy, and we're going to file a joint petition. You will submit that application with the correct filing fee, the correct biometrics fee, and the biggest part is you will need to submit continued evidence that a bona fide marriage exists. So the joint checking account bill, the trip you took last year to go visit your spouse's family in their home country, photographs, continued joint tax returns, any and all evidence that shows the service that the marriage is still going good. After you submit this petition, you will receive a notice for biometrics. You know that is common with USCIS. You will go in and you will take your biometrics. You may or may not get an interview. You may or may not get a request for evidence. That is scenario number one. Let's talk about scenario number two, where you and your spouse have fallen out of love. You have fallen out of love and you need to submit this petition on your own. Remember in video number one, I said you still have to file this petition even if your spouse is deceased, even if you have been abused by your spouse, even if you're no longer together, you are divorced. Scenario number two speaks of the waiver of the joint filing. You're now saying to the service, look, I entered into a bona fide marriage and the marriage has ended, the marriage has ended because of either abuse, infidelity, he's deceased. You still have to file this petition. For the individuals that find themselves in scenario number two, first of all, you need to consult with a lawyer to make sure you make the right decisions. But I also encourage you to go ahead and file your petition anyway. If you have not filed your petition in either scenario one or two within the 90-day requirement, you will need to submit with your application a statement, a reason as to why you failed to meet the 90-day deadline. I encourage all of you to go to uscis.gov. There's uscis.gov. There are lots of information. Join me in video number 3 as we talk about the request for evidence and the possibility that you have been called in for an interview. Until next time, my friends, walk good.